I'd like to introduce you to Petar Modev. He's a Senior Loss Prevention Executive with Thomas Miller. Petar joined Thomas Miller, or UK P&I Club, and again another sponsor of this event, so thank you very much, as a Loss Prevention Executive in 2014, having previously worked at sea as a deck officer for 8 years. He sailed mainly on oil tankers and VLCCs in particular for 5 years. Following that, he came into the offshore sector where he worked for 3 years before coming ashore into the legal area. Excuse me while I try and get up the presentation. So please make Petar feel welcome, and I will pass this over.
Thank you. First, I want to thank DYNAMARINE for inviting us on this venue. It's a really interesting event with a lot of lively discussions, so thank you for that. My presentation will cover mainly the type of risks involved in the STS operations. I will talk about the most common claim that we see in the P&I Club, and then I will talk about avoiding claims in general, and in particular avoiding claims when you do STS operations. So risks, we see risks in the club as claims. So basically I will talk about types of claims and the insurance issues that we see with the most common type of claim. By far, the most common type of claim that we see in the club is intership claims. So when a ship is struck by another, they can claim damages in negligence from the other ship. And the other third party claims cover pollution if you have cargo hose failure. They cover personal injury, in particular when you do personal transfers or moving operations. And you can have damage to third-party properties. If you talk about service providers, you can have damage to service boats, fenders, damage to fenders or lost fenders. So the most common type of claim that we see in the club is intership claims for damages in negligence. Basically, these are claims when you have low-energy collision between two ships, metal-to-metal contact. The physical damage on that case will be normally small, and the loss of earnings is usually much higher. As Martin mentioned before, it will go maybe 10 times, 20 times more than the actual physical damage. So the insurance issues with that is that, first of all, it's looked upon as a collision claim. So with any collision claim, there is heavy factual and expert evidence needed to advance in any claim. And of course, gathering such evidence is costly. Physical damage, like I said, is normally small, so it will be below the hull and machinery deductible. Loss of earnings, if you consider loss of hire cover, they normally have long deductible periods. So standard term is, I think, 14 days. If you consider charter liability to hull, it might be involved, but you have to prove that charters have have the fault for that and subject to such charter party clauses. So the only option for the tanker operators to solve this is their collision liability. Now, if I go back to the knock-for-knock contract, that's probably why the tanker operators do not go for knock-for-knock contract. Because the only option that they have to retrieve costs is to get collision liability from the other ship. This, of course, if the other ship is at fault. If your own ship is at fault, you can't get anything. And it might be to think about extended insurance. Let's say owners can think about extended loss of earnings insurance, so to reduce the deductible from 14 days to 7 days. Or the other thing that they can do is they can try and avoid claims, which I will be talking about. Avoiding claims, I will cover it only from the tanker owner perspective. So I will not talk about charterers, it's just tanker owners. The first step is, of course, the approval of the nominated vessel. And so before you agree to a STS operation, a ship will be proposed to you. Then you have to do your due diligence. You have to confirm that the ship will be compatible to your ship. So when you do that, once you do that, you're already committed. The next step will be risk assessment as per the STS transfer guide. So you have to do risk assessment on the transfer location, you have to do risk assessment on the operation itself. Appendix K in the current guidelines, STS guide gives guidelines for the risk assessment processes. The third thing that we think a tanker operator can do is a risk-based approach to STS operations. So in the UK P&I Club, we have a risk-based approach when we do ship inspections. And we think this is transferable to every operation. And the goal there is to identify critical equipment, to identify critical procedures, to put controls in place to make sure that these equipment and procedures are working properly prior you go to operations, and to have controls in place and barriers in place to make sure that even though you've done your best, incident can happen, so you have to have controls in place to mitigate consequences. The benefit of such system will be that you have something on the basis of which you can carry out focused inspections and tests prior to the actual operations. Plus, you have excellent training tool for educating your crew. Now, risk-based approach, I'm sure most of you are well aware what risk-based approach means, but for the benefit of the rest, I will start with the general, very brief explanation. So if you consider driving to work in the morning and assessing that, the hazard, getting to your car and driving to work, incident, collision with another road user. I choose not very common threat for London commuters, icy roads, so we don't see that very often. But if you consider that, the controls that you need to make sure are in place, check your car's fluids, check your tires, check that you're well rested, no distractions, switch off your cell phone, and adjust your speed. So you have a diagram, which is great illustration with one of your threats, and then all the controls in place to prevent the threat to become a collision. When you have the list of all threats, you have the whole system there. The same goes for the consequences. So your car manufacturers luckily have thought about that in advance. You don't need to do anything. You have seat belts, airbags, structural integrity of your car. So this will help you to avoid fatality or heavy injury. And that's how the whole system works. So if you have the list of threats, all list of consequences, and all controls, you have something very simple. Well, it's not simple, but it's easily visualized and very clear. So your crew can understand it. It can be very easy for them to check everything. How to make this relevant to STS operations? Well, we follow the same principles. You have hazard, the STS operation itself, incidents. We look, like I said, in incidents as the types of claims that we see. So you have collision, pollution, damage to third-party property, personal injury, and threats will be fender failure, hose failure, mooring line failure, steering failure, main engine and communication failure. just show you an example with one of the threads, let's say steering gear failure, controls in place. So this, like I said, is before your vessel goes for STS operation. Controls in place should be emergency power supply, steering gear, communication, emergency procedures. And below each and every one of these controls, you have bullet points saying exactly what specific critical equipment you have to check, what will be the measures to check it, alarms, testing, actually test running it. So let's say for emergency power supply, this might be starting your emergency generator, checking everything on your emergency generator, alarms, fuel level, making sure that routine maintenance is on schedule. For steering gear, again, routine maintenance on schedule, test the alarms, top up hydraulic oil, test the emergency steering, confirm gyro repeaters reading. For each and every one of these controls, you have different bullet points. The same goes for if an incident occurs, for controls to be in place to mitigate the consequences. So you have, we will see monetary costs, like if you consider the claim that I mentioned, the most common type of claim, you just have monetary cost there. So to resolve that, you have to keep records. If you use third-party assistance, you have to make sure that, I mean, surveyors can come on board, lawyers can come on board. You have to make sure that your crew knows who these people are and how to treat them. Do they need to preserve evidence? Do they need to not talk to them? Do they need to allow them on board at all? And learning from incidents. So lessons learned. You have something, how you do your root cause analysis, how you get that to your crews, how you circulate it even with the industry in the best case. And that's the system. If you have all the threats, all the consequences, and all the controls, you'll be ready for STS operation. And having that on board will be also part of your due diligence. And short presentation from me. That's pretty much it. I just want to, as a conclusion, to point out the three main points if we are in a perfect world. All stakeholders should perform due diligence. Joint plan of operation involving all parties, including service providers, should take place, and must have the overriding authority to abort or suspend operations for safety reasons. Thank you.
I would like to concentrate the due diligence approval and screening approach that we should demonstrate in order to have due diligence. Actually, after discussing with UK Club Greece, it was recommended to us not to use the screening approval words, because in case that the documentation we receive are not original, we are not there to defend ourselves at the dispute. This is clear ground, you know, it's the reality.
To be honest, I haven't dealt with that, so I can't answer your question.
Sir?
Liquid transfer technologies, of course, I'm a provider. Very quick question. We are in the process of STS, hose failure, pollution, and the hoses was in good condition and have the necessary certificate. We don't have, of course, a $500 million for such a claim, but who is actually responsible in this case?
Well, it should be the charterer because they're supposed to provide the equipment. I would say, but maybe Martin.
No, that's right. It's the you're back to the bow tie. You know, who's providing what equipment? Exactly right. You know, if the ship owner provides equipment, he takes on more responsibility. So as long as it's in the contract, back to the contract, make it clear.
So I don't have to insure for $500 million.
No. Well, you can do. I'm sure there'll be people who'd be very interested with that.
But the service providers generally don't have much risk, so as far as I know.
No,
But they do have insurance.
Yeah.
Can I make a comment to
Mm.
Hello? So a couple of days ago, we have an STS operation. The DYNAMARINE is all this process, so we have to ask for a co-op. So we have to run the due diligence for FOAC. We're asking them for certification, for courses, and this and that. So one of the major FOAC,
Sorry, Jens.
say the name,
Can we, if you want a question, can you ask it sort of
become
shortly?
frustrated. Perhaps Alexander knows the name. It's a big provider. It said we don't want to cooperate with DYNAMARINE. Okay, we want to cooperate with owners. We don't want to cooperate with DYNAMARINE. The bottom line is that we are not obliged, although we respect you as an owner, and we respect the nature of the question or all this investigation we're performing. However, we are not entitled to give you any of this information because we don't have contract with you in the first place, and we are only liable to our charterers who are paying for the service.
Yeah.
Thank you so much. Goodbye.
Yeah.
So is that true? I mean, there is
Well,
no
I mean, depends of the service provider. So if that's their policy, they won't go very far, I'm sure. I mean, they have to work not just with you; they have to work with all other tanker operators. And if they do the same with them, I'm sure they won't get very far.
Why should we go very far? Because they have a set of courses, should be certified.
Well, because people
Body
are,
to certify them. It's
Yeah.
not bad. They're not pirates. They should have all the systems in place for the certification. The only thing they have to do is to demonstrate.
yeah, to cooperate with you.
But
Oh.
they don't. Most of them.
There was a question here.
You know that some P&I clubs have imposed deductible law for STS operations.
Yeah, I've heard about that. Yeah.
Is this a measure of performance?
Well, I'm not sure. I know that we don't do that in the UK P&I Club. We don't have other deductibles for. Well, I don't know. Not the right person to ask, definitely.
Have you seen an increase in incidents, STS incidents in the last 5 years?
No, we haven't seen increase. But we see a few incidents every year, and like I said, the majority of them are what I have mentioned: small physical damage, and then damages in loss of earnings. That's the majority. Yeah.
So,
Hello, my name is Patrick. So I want to ask a question. Like for instance, a charter my vessel, I loaded a cargo, and usually appoint a port agent for my vessel. So on arrival to the discharge port, they took me to a jetty, whereby, according to them, the port agent, the jetty is safe for the vessel to come in. So after my coming in, after passing the line, so the vessel is alongside very well. Then a passing by, what we call a passing by vessel, make my vessel to shake and remove the bollard, one of the bollard at the jetty. So now, in this scenario, the jetty owners are asking me as a vessel owner to pay for the bollard. Who is responsible for that?
Well, Ed will answer that question.
What an amazingly unusual set of facts that was. You're quite right, and the risk of passing ships, particularly in the channels upriver in Nigeria and elsewhere, we've seen similar incidents in the US. Houston, and it's a classic problem. We have never once personally held the passing ship liable successfully. All of these incidents have ultimately then come around safe port obligations in the charter party, and the owner, who has to usually pay an extraordinary amount of money for this solid gold bollard that's been damaged, then has to seek some compensation from their charterers. But generally speaking, the safe port obligations in charter parties are a lot better and a lot more thoroughly set out in charter parties. And the basic idea is that if the vessel cannot go upriver, use the terminal and return, and that there is an incident there due to poor, if the channel authorities are not controlling vessel speeds, and that the swash or wave action from the vessels is not controlled, and you can see there's some kind of mechanism failure within that, then generally speaking you're going to have an unsafe port, and the charterers will generally be settling that claim and paying some compensation to the owner for that incident. It's enormously difficult for that owner, and a number of the harder cases that we've been involved in recently is where a vessel realises they've got upriver, the tide's going down, there's nowhere to turn, and they suddenly don't like the look of the jetty that they've been told by the local agent is safe, because they didn't get the chance to inspect it until they get there. It's an enormously difficult commercial operation for the owner to then say, I ain't doing this. But again, and I don't want to sound like a broken record, we would always encourage masters, because they often know with hindsight, I really didn't like the look of it. I went ahead with it because I thought I probably should. Create a fuss. Often a 6-hour delay, insist on getting adequate tugs there, is often the prudent thing to do, because we then spend weeks, months, years often trying to get a resolution to it and get the money back from the charterers.
One last question.
Just regarding the crew, the business of the ship always has to go on during ship-to-ship operations. In my work as a vetting inspector, I've been on ships that have been on station for up to a year. They're just using them as storage tankers, cargo coming on and off. Crew have to go on and off also. From a P&I perspective, how do you feel about the risks of 4 or 5 crew members climbing down a pilot ladder with a 3-meter swell going on in the middle of the night and trying to get home?
Well, I mean, these things, if like you said, it's a ship that is constantly doing that, obviously this should be part of the settings that we are doing and premiums that our underwriters are getting from them. But as risks, of course, risks are higher. And how to address that, maybe you can do a risk assessment and address it somehow. But you have to investigate what the problems are.
Well, because we saw on the graph that Bidencorp put there that there's been no fatalities so far on crew, but coming off during STS operations. But from what I've seen, crew members coming off ships with me, and of course I'm taking a leap of faith also, jumping from a pilot ladder onto a heavily moving launch in the middle of the night. But I do it quite a lot, and I'm used to it. But I've seen crew members coming off there, and it's just like an act of God that they actually managed to get onto the launch and not lose all their suitcases too.
Can I have a little response? Sorry, I have to say clearly, I've done it 3 o'clock in the morning the night in Kuwait on a tanker, and then being back on the LNG market, and we try to actually look at these operations. And I don't know whether it's actually LNG or it's a tanker. It doesn't really matter. The answer is not risk assessment. The answer is who has control of the safety operations in the area that is taking place. If it's within port, you're going to find out that some port authorities are very specific to what type of personnel transfer operations they allow. Billy Pugh, no Billy Pugh, side ladder, it's very clear, this cut issue. And the next sort of responsible party is the owner, i.e. the captain, usually of the vessel who is stationary there. because that becomes part of the port. This legally, the vessel who is there receiving the cargo is part of this installation, is part of this jetty. So they have a major role to play, again, in compliance of what is the local requirement. So it's not a matter of risk assessment. We will never do a risk assessment, what system to use, in what conditions, offshore or near port for transferring personnel. It's very, very clear. If you are offshore, I've just been in Israel recently in offshore operations, regasification operations. I have gone a bit into Israeli authorities allow the use of a PDQ, so we did it. Captain was with me. Yeah. We did it legally and due to the allowance. The same operations in a port within the Baltic is not allowed. Clearly not allowed. So what you have to do, either you go to port location, go through the pilot service on top of the vessel early, or don't go at all. It is not, absolutely not a matter of risk assessment. Risk assessment is a clear methodology approach. It's not a panacea and is not a word to be used arbitrarily. Please, you're opening huge legal holes.
This sounds like a wonderful discussion to bring up with bodies like Intertanko or OCINF or SIGTO even. So thank you very much.
Thank you.
If we can move on to the next speakers.